A recent High Court ruling has found that Christians do not have the right to decline Sunday working, as Sunday working is not considered to be a core component of their beliefs. The case involved an individual bringing a claim for constructive unfair dismissal against her former employer after she resigned in the face of increasing pressure to work on Sundays. The former employee in question had worked at a London children's home providing care for children with severe learning difficulties since 2007. She claimed that the home initially agreed to accommodate the requirements of her faith, but over time found that she was often allocated to work on Sundays and threatened with disciplinary action if she refused to work. In the end, she resigned from her position and claimed constructive unfair dismissal. The court considered that it was relevant that other Christians were prepared to work on Sundays and had not asked for Sundays off. The court considered that a rule imposed by an employer which affected a large number of Christians would have a greater discriminatory impact than one which only affected a few, as appeared to be the case here. Unsurprisingly, this decision had caused controversy and attracted criticism from Christian groups and campaigners. In their view, it is not the role of the judiciary to decide what is and what is not a core Christian belief, as they say this amounts to an interference in their right to practice religion. For our part, it appears that the courts have laid down a test which requires a significant number of adherents to a faith to observe a particular rule or practice before a court is willing to protect it. We wonder whether this will be applied solely to the Christian faith or whether the courts will be prepared to apply it equally to other faiths in the future, such as Islam and Sikhism. Whichever way the court rules in relation to other religions, it seems to have gone down a dangerous path, as by not applying it equally to other religions, it will face a further backlash from the Christian community, who will argue that their faith is being treated less favourably than others. However, if it is applied in the same way as in this case, the courts are likely to come under further fire from those affected faiths who will see it as a case of the courts interfering when it is not their place to do so.